So I want to thank you for inviting me so that we can share our views and perspective on what is going on with your membership and everyone that is involved. This is a very, very important case, and people must be made to feel comfortable about what is happening to their case and status in South Africa. So it's very important that when we leave the meeting, everyone is satisfied about what is happening. But before we even begin with the questions, Benjamin, I want to assure the membership, because that has been an issue that has been, it seems to be, that has been an issue that has been in the mind of everyone. So I want to assure everyone and to make it clear and categorically that we continue to represent the group in the court case, irrespective of the internal differences that you have in your group. Our representation remains firm, and we continue to be your lawyers, and will continue to be the lawyers so long as you want us to continue, and we also agree on the terms of our continuation. So there has never been a situation where we pulled out from representing you. I also want to tell the membership that I'm always in constant communication with you, and I'm prepared to work with whoever is mandated by the group to represent the group. I do not want to get involved in the internal wranglings or dynamics that is happening, but I'll work with whoever is representing the group. So let everyone know that we continue to be your lawyers on record. We've never withdrawn from representing you, despite the financial challenges that we may have encountered during some of the periods, but I believe that those have now been resolved, and we will continue doing the work.
The first question is, the former chairperson, Luke, is posting that you are no longer representing us. So you have already answered that question. I'm not going to be asking that question again. And I'll go to the second question is, did we meet any filing deadline for the court proceedings for Part A or for the SCA appeal by the DHA minister? If we did, how did we miss it, and what do we need to do to be on the safe side?
Well, Benjamin, also just to deal with the first question that you say I've already answered, but I must also make it categorically clear that we have never represented an individual. We've always represented ZIF, but we've been communicating through whoever has been at the helm or was mandated by ZIF to communicate with us. So really, any mandate that we've had has never been with an individual, but it's always been with ZIF. So we must make that point very, very clear for everyone to understand. If tomorrow ZIF tells us that you are no longer the person that is representing them and they give us another person, we will deal with whoever is put forward to represent the interests of ZIF. So this issue of individualism does not even arise, because we understand our mandate to come from the general membership through you or whoever is mandated at any given time during the course of this court case. So coming to the court case, maybe some of the members may not remember, there have always been what we call Part A and Part B of the case. Part A was about interim relief, and Part B was about the final relief. When we went to court, we succeeded on Part A, and we were given time to file for, I think the deadline for filing for Part B is somewhere in June. So that's that Part B. The deadline for Part B will be met. After we won Part A, the minister tried to appeal the court order on Part A, the interim relief. He was not successful before the Pretoria court. And when you appeal, Benjamin, just to clarify to the membership, when you appeal, you don't appeal directly. You must first get permission to appeal. So what we've been dealing with now is permission to appeal. It does not mean that the minister's appeal has succeeded. But what has happened is that the minister has been given permission to appeal. So the appeal will start, the appeal process will start. Nothing has changed insofar as the order that we obtained in Pretoria. That order remains valid and binding on the minister. What has really happened is that the minister, the Supreme Court of Appeal has, after was refused permission, the Supreme Court of Appeal has given him permission to appeal before the what we call the SCA. So nothing has changed. What really happened is because of these internal wranglings that have been happening, as well as issues of payment, there was uncertainty about our status, but it does not mean that we withdrew. And over that internal wrangling and uncertainty, we did not file papers to oppose the leave to appeal. Does not mean that the appeal has succeeded. All it says now because we did not file papers to appeal, now they've been granted the right to appeal. So now we are going to deal with the appeal once the time has, once the court has allocated the date for the hearing of the appeal. So I thought it's very important to clarify that between leave to appeal and appeal itself. In other words, the Supreme Court says, come and argue your appeal before us. The appeal has not been argued. What we were supposed to file for was whether or not they should get permission to appeal. So that has not been, it's not a significant issue in the development of the case, just to put it in perspective. For instance, if you look at the Helen Suzman case, they were denied leave to appeal. Now they have gone to the Constitutional Court to ask for leave to appeal before the Constitutional Court. That does not mean that anything has changed, whether in our case or in the case of Helen Suzman Foundation.
Thank you very much for that. I think you answered also the, some of the questions that we had as well, because the third question was, why was the SCA appeal by the DHA minister not opposed? I think you did answer that as well.
So it's not the appeal itself that was not opposed, it was their permission, their right to appeal that was not opposed.
No. Okay, all right. Thank you. I think members, I think you can hear those clarifications there. It was the permission to appeal, not the appeal itself. So I think let's get that information and also share that information in our groups in the right way. So I think the fourth question was what are the implications of the SCA appeal by the minister, and how much would it cost to oppose it, roughly?
Well, now the process is that now that the minister has been given permission to appeal, they must prepare what we call a record of the appeal. In other words, the documents that served before the High Court, they must place them before the Supreme Court of Appeal. And after that, they must do what we call heads of argument. They must put their written argument in writing, and we will respond to that. And after we respond to the written argument, we will be given a date, probably sometime this year, whether it's in July or September. We'll be given a date. If we are lucky, we'll get a date in July or September to go and argue the appeal itself. So that process itself, will require funding. Together with that process, you'll recall that we still have to supplement our Part B. In other words, we must do papers for Part B. So we'll have to run these two processes simultaneously. The deadline for Part B is in June. So the members, when you talk about cost, the members must bear that in mind, that we'll be running two parallel processes. At this stage, Benjamin, I can't give you a figure of how much it's going to cost, but it's substantial, but it's not prohibitive considering the membership that we've had. We've already you guys have already funded the first part of the case, and successfully, although there may be some fees that are still outstanding, but you did well to fund that part of the case. Obviously, the appeal itself will be far much less than the first part of the case. So that's all that I can say at this stage, that going to oppose the appeal won't be as expensive as the first part of the case when we started, because most of the work has been done. So it's just to do heads of argument and the preparation and actual appearance in court itself for Part A. For Part B as well, the bulk of the work has been done when we did Part A. So it's just now to add and supplement the case. So similarly with Part B, the costs themselves for Part B won't be as expensive as when we did the first part. But when you combine the appeal itself and Part B, that's what makes the cost, that's what will make the cost to go higher. But individually, the two cases should not be expensive, but combined, then it may look expensive.
Thank you very much for that. Thank you especially for explaining about the work that has been done already. I think that's one of the questions that were asked, that was asked at some point, to say how much work has been done. But I think, members, you can hear that some of the work has already been done as well.
Well, on the appeal, it's unlikely, because the appeal follows the process that has happened. But what may happen on Part B, you may find the other parties suddenly who wake up and want to join Part B of the case. That we can't predict. But on the appeal, it's unlikely that anyone would join the appeal itself, because that has already happened. We're just going to re-argue the Part A, whether the Pretoria court was correct to grant the order in your favor, or they were incorrect. So that's what's going to be the debate in the appeal. But on Part B, it's almost a fresh case. So you may have other parties wanting to participate. So we can't predict at this stage. Well, we have already won in Pretoria, so you can say we already have an advantage, because the 3 judges in Pretoria agreed with us, and in the SCA there will be 5 judges, and we are confident that the same 5 judges will also agree with us that we are right and the Pretoria court was right. So we're very confident about our case. That's the extent of what that's the extent of the assurance we can give you. But you know, things happen in life. But we remain confident that we have a solid case, and it's been confirmed in Pretoria that it's a solid case, that we were correct. So we will do our best to maintain that advantage.
Question number 5 says, is it possible to request, probably you would have indirectly covered this, is it possible to request the SCA to postpone the hearing of the case if ZIF has not filed or did not file the opposing papers on time? But I don't think it's still relevant, because I think you have spoken about this already.
Yeah, the only thing there is that they have to file their written argument. So we'll oppose we'll file our own written argument in preparation for the physical appearance in court. So that's the next process that should happen. Well, you remember that Part A was interim protection. That whilst we can't wait for Part B, so we needed to get interim protection, and we've got interim protection. So Part B is to make that interim protection final protection. So the issues are similar but slightly different, and also the argument on Part B will also be improved. You know, we'll add other issues. The standard for measuring Part A and Part B are quite different. It's almost more technical legal stuff about that, but Part B is simply about final protection, that the minister can't deport anyone. If they want to do anything, they must go back to the drawing board. So that's really the main difference. The standard of how you judge Part A and Part B is more final relief as opposed to interim relief. In other words, it becomes final and binding, so to speak. Well, you remember that at the beginning when we started with the case, members were allowed to deposit money directly into our account, and somewhere in the process you decided to open a different account to pay the money into, which is fine. It's not a problem. I mean, we don't have a problem with you resuming with that initial arrangement of paying the money direct into our account, and we'll do the normal monthly statement to show how much we've received and where the money has been allocated. So that's not a problem. We've been sharing some of the information with Benjamin, including the information since the inception of the case, to see exactly who's paid and where the money has been allocated, including some of the deposits that some of the discounts that we gave to the organization, because I mean the legal fees can be quite expensive, and we understand the challenges that individuals face to raise the money. So we'll continue working in that spirit that we've always had. Our approach is to avoid internal disputes or taking sides in the internal disputes of the organization. Our interest is to protect the entire membership, irrespective of who is in charge at any stage of the case. So we'll just continue that spirit, and also to be transparent. I mean, you would accept that we cannot communicate with everyone, but we trust that whenever we give information to the leadership, they share the information with you within the protocols of how you operate.
Thank you very much for that, Attorney Mabuza. I just want to mention also to the members here present that we got a discount from our bill from Attorney Mabuza of 125,096 rand and 34 cents. So yes, we are actually getting discounts from the billing from him. But I think everybody needs to know that.
Ordinarily in legal, in court cases, if a party wins, then you get some of your costs, but you never get your full costs. You get to claim, roughly speaking, 60%, 65% of the cost that you have paid, because it also depends on your arrangement with your lawyers. You may get lawyers that are expensive. So generally, the rule is that you recover 60 to 65% of your costs. The reason we've not been able to recover the cost for Part A, because the case is still being appealed. You can't recover costs when the other party is still contesting. You'll only recover the costs at the end of the process. That's why we've never spoken or recovered costs for Part A. So similarly with Part B, it will follow the same process. If we win and it's the end of the case, we will recover costs. But some of you may recall that at the very inception of the case, we did warn the membership that we expected that any party who lost this case would appeal, and it seems that we are proven correct, that if we had lost, we would appeal all the way to the Constitutional Court, and similarly we expect the minister to appeal all the way to the Constitutional Court, whether it's Part A or Part B of the case. So I'm afraid to say that you can see that the journey is still going to be a long journey, particularly with the minister that we have who feels that the court was wrong. But you know, this is the constitutional democracy. There's a rule of law. Everyone is allowed to have their case decided up to the highest court, and that's what the minister is doing. And we will do the same thing, irrespective of the outcome of the case in the Supreme Court of Appeal, the outcome of Part B of the case. We will take the fight all the way to the Constitutional Court until the highest court tells us who's right and who's wrong in this case. So that's That's a normal process. No one should feel apprehensive about what is happening. This is a big case. It's not a small case. I mean, it's a fight between David and Goliath, but it seems that at this stage we have come on top. Well, I recall that previously this issue came up, and in our discussion, it seems that the department has not been able to process the applications that have been submitted by the membership previously. So I'm quite surprised. I don't know how they're going to process 178 applications, be they for an extension or for waiver. I think they admitted in the court papers that they've not been able to process those applications. Members can decide whether they apply for extension or waiver, but as long as we continue with the legal protection, because the applications, that's a separate process, a political process that we must undertake. As long as we have a court protection, that if they delay with those applications or reject some of those applications, we still have a protection from the court order. So that would be my approach, because I don't see how they can resolve this problem in the short period of time. I mean, everything, the court case has to take its process. They must go back to the drawing board and try and find a political solution to the problem, to this problem. It's a political it needs a political solution. It started as a solution to a political problem that was happening in Zimbabwe, so it must again be resolved politically and find a solution that accommodates your interest as well. No, what it means, remember we said that the decision by the minister to revoke the permits was unlawful and illegal and unconstitutional. So Part B is going to say finally that decision is unlawful, illegal. So the minister must go back to the drawing board and look for another way of resolving the problem. The way that the minister has tried to resolve the problem has not been constitutional, has not taken into account your rights, including the expectation that you have. In other words, we've complained that there's been no consultation. We've complained that the conditions have not changed. The conditions that led to ZIP have not changed. We've complained that you've acquired rights. You have lives here in South Africa. That's where you live. So all those issues must be taken into account in whatever solution that the minister must find. In other ways, I mean, to put it bluntly, we are driving the government to a one outcome. But they must find a solution to this problem. Your lives are here in South Africa. You've been living here in South Africa for as long as you've been here. So the solution is it must be a political solution to the status of the ZEP. You must tell us what they want to do with the ZEP. No, there is nothing in the Constitution which talks about this, but what it does, as I keep on mentioning, ZEP came as a result of a political problem in Zimbabwe. So the minister must find a political solution again to this problem. You cannot simply say we no longer recognize these permits. That just doesn't work. When you give people rights and they exercise those rights, you can't take away rights. It's very difficult to take away rights. I'm sure you all know that whether rights in a workplace or in any environment. Once people acquire rights, you must respect those rights. You must either make those rights permanent, without necessarily talking about the status of the ZEP. Really, what the department, where we're trying to draw the department to, is that they must formalize the ZEP to permanency. And when I talk about permanence, I'm not talking about the permanent residence or whatever, but I'm saying that they must make those rights permanent that you have. It's a political solution that must be found. We are on brief now. What it means is that we are working for you. The fact that some costs are called costs for Part A, for Part B, and for appeal is just a categorization. But what we charge you is for work that we continue to do for you. That's. I hope that that answers the question. And you'll see that when we do the appeal as well as the Part B, because as I said, we will be running the two processes simultaneously, and you'll start seeing that